My name is Helena Voss and I am 41 years old, while I was in the hospital for 11 days following a serious car accident, unable to speak with anyone outside of immediate medical staff for most of that time. My younger sister moved our father into a memory care facility and listed his house for sale, all without telling me anything was happening. I found out 3 days after I was discharged, when a neighbor called to ask if I knew why a real estate sign had appeared in our father's front yard. What my sister did not realize, when she had our father sign the power of attorney documents she had prepared, was that he had insisted, during a moment of unusual clarity that week, on adding a single handwritten clause at the bottom of the page, one she had not noticed before filing the paperwork. That clause required my signature as well, on anything involving the sale of his property. Before I tell you what happened when I learned about that clause, please take a moment to like and subscribe. Drop your city and the time where you are watching from. I read every single comment. Let me take you back to the accident itself, and the 11 days that changed everything. I was driving home from work on a Thursday evening in October when another vehicle ran a red light and struck my car directly on the driver's side. An accident that resulted in a fractured pelvis, several broken ribs, and a head injury serious enough to require monitoring and intensive care for the first 4 days following the collision. I want to be specific about my actual condition during this period, because it matters considerably to understanding how my sister was able to proceed with decisions regarding our father without my knowledge or input. I was conscious for portions of those first several days, but heavily medicated and frequently disoriented, unable to maintain sustained phone conversations or process complex information beyond immediate, simple exchanges with medical staff and my husband, Daniel, who remained at my bedside throughout most of this period. My sister, Renata, 3 years younger than me, visited briefly during the second day, expressing what appeared to be genuine concern, before telling me she would, quote, take care of things while I recovered. A statement I did not, at the time, fully process or question, given my own significantly compromised state. Our father, Walter, 83 years old, had been living alone in the same house he and our mother had purchased nearly 50 years earlier, managing reasonably well despite increasing forgetfulness that had become noticeably more pronounced over the preceding 2 years. Forgetfulness that Renata and I had discussed, on several previous occasions, as something we needed to eventually address through some combination of additional support services or, potentially, a transition to assisted living. I want to be clear that this was a genuine, ongoing concern between Renata and me before my accident occurred, not something either of us had been ignoring or avoiding entirely. We had discussed specifically scheduling a comprehensive cognitive evaluation for our father sometime in the following month, intending to use those results to guide whatever decisions ultimately made sense regarding his living situation and his legal and financial affairs. My accident occurred precisely during this period of ongoing, unresolved family discussion, creating, apparently, an opportunity that Renata chose to act on independently rather than waiting for my recovery or for the more comprehensive evaluation process we had previously discussed together. I learned, considerably later, piecing together the actual timeline from various sources, including Daniel, our father's neighbor, and eventually documentation Renata herself was required to produce, that she had visited our father on the 3rd day following my accident, while I remained in intensive care, and had presented him with power of attorney, documents she had apparently prepared in advance of this visit, documents that would grant her authority over his financial and medical decisions. I want to be specific about our father's cognitive state during this particular visit, because it became, eventually, significant to everything that followed. Walter experienced considerable variability in his cognitive clarity during this period, some days and even some hours within a single day, representing periods of reasonably clear thinking, while other periods involved noticeable confusion and disorientation. According to what I eventually learned, Renata's visit occurred during what appeared to be one of his clearer periods. Walter, engaging with the documents she presented with apparent understanding of their general purpose, though the specific extent of his comprehension regarding all the detailed implications remains something I have never been able to fully establish with complete certainty. What I do know, with considerably more certainty, having eventually reviewed the actual documents myself, is that Walter, during the same visit, insisted on adding something to the standard power of attorney form Renata had brought, a handwritten addition at the bottom of the relevant page that read, in his own distinctive handwriting. Any sale of the house requires both my daughter's signatures, followed by his own signature beneath this addition. I do not know, with complete certainty, what specifically prompted Walter to insist on this particular addition during that visit. Daniel later suggested, based on his own conversations with our father during subsequent visits, that Walter retained, even during periods of broader cognitive confusion, a persistent, specific concern about the house itself, the home he and our mother had built their life together within. A concern that perhaps manifested during this particular moment of relative clarity as an instinctive insistence on ensuring both his daughters remained involved in any decision regarding its sale, even if he could not fully articulate or remember the broader context of the legal document he was otherwise signing. Renata, according to what I eventually pieced together, either did not carefully review this handwritten addition before filing the completed power of attorney documents, or did notice it, but did not consider it legally significant enough to address directly. Proceeding over the following week to arrange Walter's transition into Lakeside Memory Care, a facility specializing in dementia and cognitive support services, while simultaneously contacting a real estate agent to list the house for sale. I want to walk through, specifically, the timeline of these actions, because their compressed nature matters considerably to understanding how rapidly this entire process unfolded relative to my own hospitalization and recovery. Walter moved into Lakeside Memory Care 6 days after my accident. The house was listed for sale 8 days after my accident. I was discharged from the hospital on day 11, still recovering significantly, requiring considerable rest and limited mobility. Genuinely unaware that any of these actions had occurred during my hospitalization, I learned about the situation on day 14, 3 days after my discharge, when our longtime neighbor, Carol Pemberton, called specifically to ask whether I knew anything about the real estate sign that had appeared in Walter's front yard several days earlier, mentioning that she had assumed, given the timing relative to my accident, that perhaps I simply had not yet had the opportunity to mention this development to her directly. I want to be honest about the genuine shock and disorientation I experienced during this phone call, still recovering physically from my own injuries, processing simultaneously both the news that our father had apparently been moved into memory care without my knowledge, and that his house, our childhood home, was already actively listed for sale. I called Renata immediately following this conversation with Carol, asking her directly to explain what had happened during my hospitalization. Renata's explanation during this initial phone conversation focused primarily on the genuine urgency she had perceived regarding Dad's safety, describing specific incidents during the period immediately following my accident, where he had apparently left the stove on unattended on 2 occasions and had, on a 3rd occasion, become genuinely lost while attempting to walk to a nearby grocery store he had visited independently for years. I want to be clear that I do not doubt the genuine seriousness of these specific safety concerns, nor do I dispute that some transition toward additional support or supervised living likely needed to occur reasonably soon, regardless of the timing relative to my own accident. My concern, when I confronted Renata during this conversation, focused specifically on the complete absence of any attempt to include me in these decisions, even through brief, simple communication that could have occurred despite my own hospitalization, and on the additional, separate decision to immediately list the house for sale, rather than simply addressing the more immediate safety concerns regarding his daily living situation. I asked Renata directly during this conversation whether she had reviewed the complete power of attorney document Walter had signed, specifically asking about any additional handwritten content beyond the standard formatted language. She told me, somewhat dismissively, that Walter had added some, quote, note at the bottom that she had not considered particularly significant, given that he was, in her assessment, not fully cognitively capable of understanding the formal legal implications of whatever he had chosen to write, suggesting that I should not place excessive weight on something added during what she characterized as a period of generally compromised cognitive function. I want to be specific about how I responded to this characterization, because it represents the actual core disagreement that eventually required formal legal resolution. I told Renata directly that if Walter's cognitive capacity during that visit was sufficiently questionable to disregard his own handwritten addition to the document, The same questionable capacity logically called into question the validity of the entire power of attorney document itself, not simply the specific portion that happened to be inconvenient to her subsequent actions. I consulted an elder law attorney the following day, a careful, experienced woman named Patricia Onwegbu, who specializes specifically in cases involving disputed power of attorney documents and questions of capacity in elderly clients. Patricia reviewed the actual signed document, including Walter's handwritten edition, during our initial consultation, explaining that the specific language he had added, requiring both daughters' signatures for any property sale, represented a legally binding modification to the standard power of attorney terms, provided Walter possessed sufficient capacity at the moment of signing to understand the general nature of what he was executing. A threshold that, Patricia explained, was generally considered separate from and less stringent than full, comprehensive understanding of every detailed legal implication. She explained that Renata's own characterization, suggesting Walter lacked capacity specifically regarding the handwritten edition, while simultaneously relying on the validity of his signature for the broader document, created a genuine legal inconsistency that would likely prove difficult to sustain if formally challenged. Patricia drafted a formal letter to the real estate agent handling the listing, along with separate correspondence to Renata directly, establishing clearly that the house sale could not proceed without my own signature, per the explicit terms Walter had personally added to the controlling legal document. The real estate agent, upon receiving this notification, along with a copy of the actual signed document showing Walter's handwritten edition, immediately suspended the listing, recognizing the genuine legal complication this edition created regarding clear title and proper authority to proceed with any sale. Renata's response to this development, when she eventually contacted me directly following the real estate agent's notification, was considerably more confrontational than our initial phone conversation had been, accusing me of deliberately obstructing necessary arrangements for our father's care funding, given that the proceeds from the house sale had been intended, at least in part, to help cover the substantial ongoing costs of his memory care facility. I want to address this specific accusation directly because I think it represents a genuine, legitimate concern that existed alongside the more troubling aspects of how Renata had proceeded without my knowledge or input. I told Renata, clearly, that I was not opposed to eventually selling the house, recognizing that our father's care costs were genuinely substantial and that the house itself represented his primary available asset for covering those expenses. My objection focused specifically on the manner in which she had proceeded, entirely unilaterally, during a period when I was hospitalized and unable to participate in decisions, rather than waiting even a brief additional period to allow my own input and agreement regarding both the facility placement and the eventual sale terms. I proposed, during this conversation, that we proceed together, jointly reviewing the actual financial requirements for Dad's care, jointly selecting appropriate terms for the eventual house sale, and jointly ensuring that whatever proceeds resulted were managed transparently and appropriately for his ongoing benefit, rather than continuing to proceed through unilateral decisions made without my participation. Renata initially resisted this proposal, suggesting that the urgency of the situation, combined with my own ongoing recovery, justified her having proceeded independently, and that requiring my formal involvement now represented an unnecessary delay, given how much progress she had already made arranging Dad's care. Patricia, working alongside me throughout this process, eventually arranged a formal mediation session, recognizing that continued direct conflict between Renata and me was unlikely to produce a resolution that adequately served either our father's actual needs or our own relationship as siblings going forward. This mediation, occurring roughly 3 weeks after my initial discovery of the entire situation, finally produced an agreement that both Renata and I found acceptable. We would proceed with the house sale jointly, with both of us reviewing and approving the specific listing terms, the eventual sale price, and the management of resulting proceeds, all of which would be directed specifically toward Dad's ongoing care costs through a jointly managed account requiring both our signatures for any significant withdrawal. I want to address directly what this entire experience revealed about my relationship with Renata, recognizing that the underlying conflict extended considerably beyond simply this specific incident regarding the house sale and Dad's care transition. Renata and I had maintained, Throughout most of our adult lives, a relationship characterized by periodic tension regarding decision-making authority within our family. Tension that I recognize now with considerable clarity. This particular incident brought into sharp, undeniable focus rather than representing some entirely isolated aberration in our otherwise straightforward sibling relationship. I do not believe Renata acted, during my hospitalization, with any deliberate intention to permanently exclude me from decisions regarding our father. I believe, more charitably, that she perceived genuine urgency regarding his safety, combined with a long-standing pattern of assuming primary decision-making authority within our family, that my own hospitalization simply provided unusual, expanded opportunity to exercise without the typical friction my own involvement usually introduced. Walter has remained at Lakeside Memory Care since his initial placement, an arrangement that, despite the troubling circumstances surrounding its initial establishment, has ultimately provided him with appropriate, attentive care that has measurably improved his daily safety and his overall quality of life compared to his final months of increasingly precarious independent living. The house sale, proceeding jointly between Renata and me following our mediation agreement, completed roughly 2 months ago. The resulting proceeds, now managed through the jointly controlled account specifically dedicated to covering Dad's ongoing care costs, an arrangement that has genuinely simplified rather than complicated our ongoing financial management. Regarding his care, I think, often, about how close this entire situation came to proceeding entirely without my knowledge or input. Had Walter not insisted, during that specific moment of relative clarity, on adding his own handwritten requirement regarding both daughters' signatures, a single sentence that, I genuinely believe, reflected some deep, persistent awareness on his part regarding the importance of maintaining both his daughters' involvement in decisions about his life and his home. Even as his broader cognitive capacity continued declining in other respects, I am genuinely grateful for that specific addition, recognizing that without it, the house would likely have sold entirely without my input. The proceeds managed entirely according to whatever terms Renata alone determined, during a period when I remained completely unable to participate in any of these significant decisions regarding our father's care and our family's most significant remaining shared asset. That is my story. If you have ever discovered, after a medical crisis or significant absence, that decisions had been made about your family without your knowledge or input, I want to hear about it. Drop it in the comments, and if this story reminded you that even small, seemingly minor additions to important documents can sometimes matter enormously, share it with someone who needs to hear that today. I will see you in the next one.